Well, let's go ahead and get started. It is 6:35, and I know that I am so appreciative that you would all take time out of your evening to join us tonight and listen to some of these updates and hopefully get your questions answered. That's the most important part about tonight. Little housekeeping before we get started. Um, we will be recording this video, so you'll be able to access it again on our YouTube channel. All of the videos or all of the webinars that we have held so far have been recorded and are available on that YouTube channel. We will send you a link to that following this presentation. If you have questions, down at the bottom of the screen, you see the little Q&A. That's where we want you to please post your questions. And when we get through the presentation, we will answer as many of them as possible, hopefully all of them. But if not, we will get back with you on the responses for those that we missed. I want to make sure that I introduce to you a few people here. First, we have Fran Green. Fran is RealComp's marketing manager and is responsible for putting all these events together. She's been with RealComp since it started. She brings a ton of knowledge and experience to us, and we're very appreciative to have Fran as one of our team. Also, we have Pat Jacobs, and I know you all know Pat. She has been your EVP for 43 years. And you should be very grateful to have Pat at the helm because she's a wonderful advocate for all of you. I'm Karen Cage. I'm the CEO at RealComp. And I want to take just a minute to introduce to you Brian O'Keefe, who will be leading you through the majority of this presentation tonight. Brian is a founding partner of Lippitt O'Keefe PLLC, a Birmingham, Michigan-based law firm. He supervises the firm's transactional, real estate, business, and personal planning departments. Brian has been serving Southeastern Michigan businesses, entrepreneurs, and their families for almost 40 years. Brian is also outside general counsel to RealComp, the largest real estate multiple listing service in the state of Michigan. Over the course of his career, Brian has been legal counsel in transactions with a cumulative value in excess of $1 billion. Brian received his Bachelor of Arts degree from Michigan State University and received his Juris Doctor degree from the Catholic University of America. Brian's professional memberships include the State Bar of Michigan, the Oakland County Bar Association, and the American Bar Association. Brian is a longtime philanthropist and has served on numerous community and company boards and committees, including the Manresa Retreat House and the Young Entrepreneurs Organization. Brian lives in Birmingham with his wife, Robin, and their 4 children. So, Brian, if you want to start, we're ready.
All right. Thank you, Karen. Good evening, everyone. Thank you for joining us. I know it's been a long day, I'm sure, a lot of real estate activities going on. So we thank you for taking a couple of hours out this evening to listen to this town hall and hopefully to get a good update on where things are going in the future in the real estate industry. Thank you, Pat, for having me. I think we were talking earlier, and NOCBOR is now the largest association of realtors in the state of Michigan, almost 8,000 strong. So as a long-standing Oakland County resident, I applaud that. So thank you and welcome, everyone. As a very thorough lawyer, I have to have a good disclaimer. So let me read you and start off with a disclaimer for this town hall. Due to the nature of this town hall, please be advised of the following. The information disseminated during this town hall may not be exhaustive of the subject that is covered during this town hall or of all of the subjects which may impact the business of the participants of this town hall. By disseminating information during this town hall, Lippitt O'Keefe and its agents are not inviting or establishing or intending to invite or establish any attorney-client relationship, principal-agent relationship, or any other legal or business relationship. I'll probably provide some legal advice as we go along here, but I can't represent any of you through this town hall. The attorneys of Lippitt O'Keefe are licensed to practice law only in the state of Michigan, and nothing during this town hall shall be construed to constitute legal advice under the laws of any other jurisdiction. The attorneys at Lippitt O'Keefe are not accountants nor tax advisors, and nothing during this town hall shall constitute or be construed to constitute tax advice or a tax opinion. And by participating in this town hall, Lippitt O'Keefe PLLC and all of the participants of this town hall are not intending to coordinate the actions of competitors in violation of state or federal law, but rather we are sharing information in an attempt to comply with applicable state and federal law. We're going to go through a number of topics and issues. This is a little overview of what we're going to talk about. We're going to talk about the genesis of the Sitzer and Morrill cases, the nationwide settlement that arose out of those cases, practice changes that have been required as a result of the settlement, the implementation and timing of all of those practice changes, changes to MLS forms and the MLS system. And then we'll have a Q&A, as Karen mentioned. We're interested in all of your questions, and we'll endeavor to answer as many as possible. The Sitzer and Morrill cases. So the real estate industry has been under scrutiny for probably 70 plus years, even longer than Pat and Karen and I have been around. Why is that? Well, number one, the real estate industry is one of the leading industries in the country. As you all probably know, everybody watches home sales. Everybody watches the prices of real estate as they go up and down. It's a very, very important industry that all of you are participating in. Number two, NAR has been a very strong proponent of the industry, whether you love or hate NAR. It has a very strong association. It's one of the largest associations in the country. And all of you out there are colleagues and participating in the same industry, but you're also competitors with one another. You're competing to list homes. You're competing to represent buyers. And so when any industry looks as if there's a coordination of activity amongst competitors, it gets scrutiny. Back as early as the 1950s, there was scrutiny on the industry, and changes were made by NAR through that time period. But in 2017, a large class action known as the Sitzer lawsuit was brought in the state of Missouri. This lawsuit only was brought on behalf of sellers of real estate in the state of Missouri, but the plaintiffs and the plaintiffs' lawyers claimed that real estate commissions were too high, and they were too high as a result of the NAR rule on cooperative compensation, cooperation amongst real estate individuals. As I said, this was brought in the state of Missouri. Subsequently, shortly thereafter, the Morrill lawsuit was brought in the state of Illinois, the Northern District of Illinois. This case was a much larger case. It involved homeowners across the country. The plaintiff's lawyers in that case named NAR again, and it named a number of big brokerage firms across the country. So it was a much more significant case. And again, they implicated primarily the mandatory compensation and cooperation rule. During this same time, the Department of Justice was investigating the National Association of Realtors. It was very interested in a number of the National Association of Realtors rules. Again, it was the DOJ and the FTC were advocating that real estate commissions were too high, and they thought that the real estate industry was not being transparent in connection with its commissions. So they investigated NAR very thoroughly. The parties got close to a settlement in 2020. On the eve of the settlement, the Department of Justice withdrew from the settlement agreement, saying that some of the things that NAR was asking for, and one of the things that NAR was asking for was sort of a free look, a get out of jail free card that said that if they're going to settle, that the DOJ would not look at it and scrutinize it going forward for a period of time. The DOJ backed out of the settlement agreement on the eve of it being finalized. NAR tried to enforce the settlement agreement, by appealing to the United States Court of Appeals, saying that the settlement had been fully effectuated. The FTC objected. The FTC and the DOJ objected, and it was finally determined that the settlement agreement was not effective. So the DOJ is going to continue to scrutinize the National Association of Realtors. It's going to continue to scrutinize the MLSs, which are responsible for implementing the NAR rules, and it's going to continue to scrutinize the real estate industry in full. There are other rules that are already being investigated by the Department of Justice. So we'll have to see how things play out in the future. What this really means is that we're not done with perhaps changes in the industry, perhaps changes in the rules that we all have to abide by. The Sitzer case went to trial in October of 2023, almost a year ago now. And after a long trial, and as many of you know, most cases in the country do not go to trial. Less than 5% of all of the cases go to trial in the United States. But this case did go to trial. It was tried before a jury. The jury awarded the plaintiffs a whopping $5.36 billion in damages. Now, mind you, this was only damages that home sellers in the state of Missouri were alleged to have suffered as a result of the NAR policies. It did not include homeowners in any other state other than the state of Missouri, and it only included a 6-year period of time. So it was an astronomical loss for NAR. It was an astronomical loss for the industry, and it was an astronomical win for the plaintiffs. Basically the jury and the court ruled that the NAR policy, the clear cooperation and compensation policy, had the purpose and effect of raising, inflating commission prices paid by home sellers. Immediately after the case was decided, as you can imagine, dozens of copycat cases were filed throughout the country, and the Morrill case, which was filed shortly after the Sitzer case, started to head to trial. This led to NAR and many of the large brokerages that were named in the Sitzer case and that were named in the Morrill case seeking a settlement of both the Sitzer case and the Morrill case, and seeking a national settlement. I was involved in a big meeting last fall with all lawyers from across the country representing MLSs and associations, and NAR lawyers were there, and we all talked about how if we were ever to get anywhere and end this litigation, we needed to settle the matter on a nationwide basis. And NAR was luckily able to do that, along with a number of large brokerages. So a settlement was announced in March of 2024. The settlement is 90% in place, but as we go through the summer and the fall, there are a number of things that still have to be accomplished in order for the settlement to be finally effective. It will probably be finally effective in December of this year, when a judge rules that it is in full force and effect. One of the things that's happening is that the plaintiffs lawyers are notifying all of the class of plaintiffs that the settlement is taking place. And many of you know from experiences in other arenas, whether you've been involved in cigarette litigation or breast implant litigation or other class actions with regard to securities, that everybody in the class has to be notified. People in the class have to have a time to consider whether or not they're going to opt in or out of the class, and take some time to get everybody on the same page. In the meantime, on the defendant side, all of the MLSs and all of the brokers and all of you have to implement the rules and procedures that are part of the settlement agreement. So as I said, it's a nationwide settlement. The settlement resolves claims against NAR. It resolves claims against all local realtor associations across the country. It resolves claims against all association-owned MLSs. and it resolves claims against brokerage firms with a principal who is a realtor and whose 2022 volume was $2 billion or below. So those are the people that are those are the groups that are automatically covered by the settlement. There's been some discussion about whether brokerage firms with volume below $2 billion need to do anything. For those of you out there who are brokers who have a volume in 2022 below $2 billion, you need not do anything. You need only to comply with the settlement agreement going forward. We as an MLS had to opt into the settlement agreement, which we have done. And the realtor associations that are shareholders in RealComp are covered by our opting into the settlement. The settlement amount was approximately $418 million. So as you can see, there was a great incentive on behalf of the defendants in the case to settle the case. NAR's liability was reduced from 5.6 billion plus to 418 million, some portion of 418 million. Many of the large brokerage firms are contributing to that amount. And the settlement covers, from a plaintiff's side, the settlement covers all persons who sold a home listed on an MLS anywhere in the U.S. where a commission was paid to any brokerage in connection with the sale of the home. In Michigan, that included all home sales that were covered from October 31st, 2017 onward. Home sales before that time are really barred by the statute of limitations. No one in that group can really bring a claim. And this covers everyone that sold a home from October 31st, 2017 onward. There were some questions in the past about people, brokers and agents asking whether their clients that were home sellers will be receiving money, some remuneration. If one of your clients asks you this, they will receive a notice. If they sold a home after October 31st, 2017, they will receive a notice. They will have a chance to opt into the class. If they opt into the class, they will receive some amount of settlement. If you do the math, you can kind of figure out that it won't be very large because 418 million spread across home sellers across the country, home sales from 2017 on. As you can imagine, that's millions and millions of home sales. So they will receive some portion of that $417 million. And of course, the plaintiff's lawyers will receive a nice payday as well. Two particular entities are not covered by the settlement automatically. Brokerages with residential transaction volume over $2 billion in 2022 are not covered automatically. So for those of you who are with a brokerage that had a transaction volume over $2 billion in 2022, you should consult with your attorney. There was a methodology for opting into the settlement. Hopefully you have been advised as to how to do that, and you can make a determination as to whether or not you would like to do that. Non-realtor MLSs, those MLSs that were not association owned, also were not automatically covered. They had the opportunity and option to opt into the settlement agreement. Some have chose to, some have chose not to, and many brokerages with transaction volume over $2 billion in 2022 have determined not to opt in quite yet. Primarily, these groups are fighting over the amount of damages that they'll have to pay. By opting into the settlement, there was a formula by which they had to pay some damages. By staying outside of the settlement, they then run the risk of being sued separately for damages by these plaintiffs' lawyers or other plaintiffs that might feel like that they paid too high of commissions. But this is not really for RealComp's consideration. But those of you out there that are brokerages that fall in the group that's not automatically covered, please consult with your attorneys. There's still time to opt into the settlement. So RealComp is a released party under the agreement. It does not have a monetary obligation. We executed Exhibit B timely, which is the methodology for opting into the settlement agreement. So we are fully covered. As an aside, RealComp was never a defendant there's been some scuttlebutt, if you will, going around that RealComp was a defendant in the action. RealComp was not a defendant in the moral lawsuit. We were named as an interested party, and we had to provide some documents by way of a subpoena, but we were not a defendant in that lawsuit. Unfortunately, none of the Michigan was sort of left out of the class actions. So most of the brokerages in Michigan, the associations that are our shareholders and RealComp were not named in lawsuits, which was why we were very interested in entering into the settlement agreement. All National Association of Realtor members, subscribers, those of you who pay dues to the National Association of Realtors, you're all covered by the settlement, which means that you can't be individually sued. Unless you're an independent contractor or an employee of Home Services of America or one of its affiliates, you're covered by this settlement. Home Services of America is one of the defendants in the Sitzer case that continues to fight with the plaintiffs about its liability, and so it hasn't yet settled fully with the Sitzer plaintiffs. I think I covered the point about brokerages, so we can go on to the next slide. So what does the NAR settlement require? The settlement deadline is August 17th of 2024. We've already begun the implementation on RealComp's behalf. The very first and most important part of the settlement is that offers of compensation are now prohibited from being put forth anywhere on the MLS. As such, all compensation-related fields were removed from RealComp during the week of July 15th. MLSs across the country are doing the same thing. Those who wish to be covered by the settlement are required to remove offers of compensation from the MLS. Brokers and agents must now communicate offers of compensation via phone, email, in person, through websites, etc., but not through the MLS. As I've said in prior town halls, all of us like to move forward in our lives. We're happy when there's innovation and positive movement forward. But in some ways, this is requiring us to go back to the way that we're doing business in the 1980s, before the advent of the internet. You have to communicate with each other through phone or email or in person, and through documents. You can use your own email systems. You can correspond with one another through email, through text message, any other way that you feel comfortable in doing so, but you may not make offers of compensation on the MLS. To address this issue of agents posting compensation in remarks or otherwise, we are going to begin running a cleanup routines in August. We're already starting those, and we are going to be removing non-compliant references to compensation in the remarks fields as well. So for those of you, and no one is accusing anyone of anything, but there are a lot of creative people, which is wonderful. But if people are going to try to sort of give an indication of what compensation might be through the remarks section, we are not going to allow that to happen. It's very important for the MLS that we not allow those kinds of things. The MLS was made sort of the watchdog of all of this settlement. Since the MLS was used by NAR to implement all of its rules, the MLSs sort of got the brunt of the of the settlement by being both the watchdog and held to a higher level of scrutiny. So as RealComp's attorney, I'm responsible for being sure that RealComp complies. I want to keep RealComp out of litigation. I want to keep all of our association shareholders out of litigation, and I want to keep all of you out of litigation. It doesn't really benefit anyone for there to be litigation over any of these matters. Also, one of the main parts of the settlement is that certain disclosures need to be made. The most important disclosure that must be made is that broker compensation is not set by law and is fully negotiable. This disclosure has to be made in a number of areas. I'm going to get into the details of that, but it's very, very important that this disclosure, broker compensation is not set by law and is fully negotiable, be made in our various documents and in the MLS. This was a very important part of the settlement agreement. I'm summarizing things at this town hall that are of the most important parts. Things are changing as we go forward. They're changing on a daily basis. I'm in contact with NAR and its lawyers on a weekly basis. Many of the questions and concerns that all of you have were not fully considered or thought through by some of the people sitting in the ivory towers in Chicago and in other states. A lot of the things were fully considered, but of course, with all of us with our feet on the ground trying to implement all of this, there are a number of things that were not fully thought through. And like most settlement agreements, there are ambiguities. So we have to move forward and be flexible in how we address these issues. And we're trying to do that on a daily and weekly basis. And so we will keep you all apprised through these types of town halls going forward, through FAQs that we're going to be posting on RealComp's on the RealComp website, etc. If you want to follow all of this yourselves, besides the things that appear in the trade journals, many of which I would say are inaccurate or not fully thought through. News is not always the most thorough of sources. You can go to facts.realtor, which is a realtor, which is the NAR website, and facts.realtor will keep you up to date on the actual and full aspects of the settlement agreement. So two other things that are important to consider, two other major changes that are important to consider, is that MLS participants and subscribers must not represent that their brokerage services are free or available at no cost to clients. The plaintiff's lawyers and the plaintiffs alleged that a lot of times buyer brokers were saying to their buyer clients that, hey, my services are free. I'm going to be paid by the seller. The allegations were that was deceptive. It was a misrepresentation. So there's a statement in the settlement agreement that MLS participants and subscribers must not represent that their services are free or at no cost to a client. Of course, if you are going to represent someone and there is absolutely no cost or compensation, you're going to represent a family member or a friend. That doesn't mean that you can't represent them for free. You just can't represent them and tell them it's free when it's not free. There's also now, very importantly, a written agreement that's required between the MLS participant and the buyer. You must have this agreement in place before you show your purchaser buyer the first home. If someone says to you, and so we've been asked a lot of questions on this issue. If someone says to you, you know what, I'm not quite in the market yet, but I've got some free time on Saturday and you and I are friends and let's go out and spend our Saturday afternoon, have a cup of coffee and spend our afternoon going out and looking at some open houses. That may not implicate this rule. You have to make a determination yourself. But if someone has come to you as a client, a customer, and said, I want to go look at homes, I want you to represent me, let's go out and look at these 6 homes on Saturday, then you have to have in place before you go out with them a written agreement that goes into detail about your representation, which I'll get to in a minute. We have developed on behalf of RealComp a purchaser agency agreement, traditional purchaser agency agreement otherwise. And these documents are in the RealComp form bank. you don't have to use these agreements. We're not trying to substitute our judgment at the MLS for the judgments of the brokers or the associations that might have forms. We've developed these forms to be compliant with the settlement agreement so people can see them. And we've spent a lot of time, a lot of effort, a lot of negotiation back and forth, making these forms compliant with the settlement agreement. So you can look at them for your own edification, for your own knowledge, but you can certainly use other forms that your broker has developed, that the associations have developed, so long as they're compliant with the settlement agreement. And I'll get into some of the precise language that needs to be in these forms. But as I said, the forms that we've developed on behalf of RealComp that are in the form bank are compliant. The listing agreements must contain language that says brokerage commissions are not set by law and are fully negotiable. The language has to be conspicuous. It has to be clear. And again, the forms that we've developed on behalf of RealComp, the IRTS form and the exclusive agency form and the MLS only form, they have this language in there. Those forms are also available in the RealComp form bank. Again, we're not saying that you have to use these forms. I'm sure that the brokers and the national brokers and the other brokers that are developing equally good forms, but we want everyone to be able to see what we believe are forms that are compliant with the settlement. Another important aspect of the rule, and this is one that's causing a lot of trouble and a lot of discussion as to how to best implement it, is that MLS participants acting for sellers must conspicuously disclose to sellers and obtain seller approval for any payment made to another broker. The disclosure must be in writing, must be made in advance of payment, and must specify the amount of payment. So what the plaintiffs in the Sitzer and Morrill cases wanted to have happen, and the way the settlement agreement was devised, is that brokers acting on behalf of sellers will determine with their clients what a commission amount should be. And buyer brokers acting on behalf of buyers will determine what their commission amount will be. And then there could be a coming together of the seller broker and the buyer broker to determine how those commissions should be shared. Again, it's not that different than what was happening in years gone by, many, many years ago. So in order to do this in an effective way, we've developed a co-broker compensation and cooperation agreement. This is a document that can be signed by the buyer broker and the seller broker, and importantly, the seller to comply with this rule so that the seller knows that of the 5% commission that he has agreed to pay, he or she has agreed to pay, that 2.5% is going to the seller broker and 2.5% is going to the buyer broker. And I use that only as an example. It can be 4% to the seller broker and 1% to the buyer broker. And it can vary between in various deals. It can be changed. If you as a seller broker feel like a buyer broker has brought to you a very important, your house has been on the market for 2 years, and the buyer broker has brought to you a qualified buyer, and previously you thought, you were only going to pay a buyer broker 2%, but this buyer broker has brought someone that's going to close with cash in 7 days, then you can offer 4% or any other number. So it can be a deal specific to the circumstances of the transaction. We have a broker compensation and cooperation agreement that allows for all of that to happen. The multi-listing service, this is another very important rule for us as the MLS. The multiple listing service shall not fix, control, recommend, suggest, or maintain commission rates or fees for services to be rendered by participants. Further, the multiple listing service shall not fix, control, recommend, suggest, or maintain the division of commissions or fees between cooperating participants or between participants and non-participants. Further, we were held to even a higher standard. As I said, rightfully or wrongfully, the MLSs were made to be the party to implement and govern all of this. There's even in a section in the settlement agreement that says, and I'll read from the settlement agreement, the MLS agrees not to create, facilitate, or support any non-MLS mechanism for listing brokers or sellers to compensate buyer brokers or sellers. So we as the MLS have to be very careful that we're not putting into place some alternative methodology for all of this happening. We have to let all of you go out and do this independently and on your own. And that's why we're being careful in advising everyone of this and making sure that we don't put ourselves in harm's way. So, as I said, sellers may not make offers of compensation to buyer brokers or other buyer representatives in the MLS. You should use the co-broker cooperation and compensation agreement or some document like this to agree upon compensation between the listing broker and the buyer broker. One such document is this co-broker cooperation and compensation agreement. Again, we're not trying to substitute our judgment for associations, for brokers. Brokers may decide that some other document is more effective. All of you might create your own documents, but there should be a document outside of the MLS to agree on compensation between listing brokers and buyer brokers. Besides the fact that the settlement agreement mandates this, it only makes good business sense that you have written agreements between one another to be clear on what commissions are being paid and how they're going to be paid and when they're going to be paid under what circumstances. As many of you know, as licensed professionals, the statute of frauds requires writings in connection with real estate matters. There's an argument that commissions are not covered by the statute of frauds because it's not directly real estate. It's compensation in connection with real estate, but it only makes sense in the real estate industry and in many other industries that you have clear written agreements so that everyone knows what's going on. So MLS participants and subscribers must disclose to prospective sellers and buyers that broker compensation is not set by law and is fully negotiable. This must be included in conspicuous language as part of any listing agreement, buyer written agreement, and any pre-closing disclosure documents. We are including in the RealComp form bank documents from other sources, not just the RealComp sourced documents. We're going to allow association documents, broker documents, etc. But we are being very careful about how those documents look. To the extent that those documents don't have the necessary disclosures, we are going to send people back to the drawing board. We're not doing this to be difficult or to be proponents of our forms over any other party's forms. We're doing it so that all of you and all of our shareholders and RealComp do not face lawsuits in the future. Again, you must conspicuously disclose in writing and obtain this in writing to sellers and obtain the seller's authority for any payments or offers of payments that the listing participant or seller will make to another broker or representative of a buyer. This disclosure must include the amount or rate of the payment. It must be made in writing, and it must be made in advance of the payment being made. So you can't have a handshake deal with, as a seller's broker, you can't have a handshake deal with a buyer broker that, hey, I'll take care of you at the closing, we'll get you your 3%, and not tell the seller that you're doing that. That's a violation of the settlement agreement. Things should be disclosed and made clear to the seller and the buyer in advance of the representation. And this is true. This is true. We've heard questions and rumblings about the unfairness or why is the real estate industry being discriminated against or held to a higher standard? This is really true in any industry where there's a principal agent relationship. For instance, and I've used this example before. For instance, if I'm a lawyer representing a wife in a divorce, and it turns out that the husband is going to pay my legal fee because he's earning all the money, and he's going to pay both lawyers a legal fee as a result of when the divorce is finalized, I have to disclose that. Why is that? Because of the duty of loyalty. You don't want to have a perception that you're loyal to someone other than your client. So despite the fact that I'm getting paid by the husband in this divorce, I have to tell his spouse, my client, the wife, that despite all of that, I'm going to be loyal to her. It does not matter who I'm being paid by. This is a similar situation. There was allegations that in some of the lawsuits that there was a mixed duty of loyalty because buyers agents were getting paid by sellers and seller brokers. So the settlement was designed to cure these perceived inequities or issues. The buyer, there's a requirement that, as I said, before the buyer is shown the first home, that there must be a written agreement in place. Written buyer agreements must have specific and conspicuous disclosure of the amount or rate of compensation that the participant will receive, how this amount will be determined, and to what extent the participant will receive the compensation and from what source. The compensation has to be set forth in a manner that is objectively ascertainable and not open-ended. There's been a lot of questions about this. You can't have in your buyer agreement, buyer broker buyer agreement, you can't have a statement that says, I'll be paid whatever the seller will pay me, or I'll be paid at closing in an amount to be determined. That is not objectively ascertainable, and it is open-ended. You can have a sliding scale. You can say, if I show you a home that's $1 million plus, I get X. And if it's less than $1 million, I get Y. If I have to work for 6 weeks, I get X. If I work less than 6 weeks, I get Y. It can say, I will take $5,000 from you. And if the seller is offering me more than $5,000, you'll get a credit from the seller for the $5,000 plus whatever I receive from the seller. But in connection with that, you cannot receive compensation greater than what you've told your buyer you're going to receive. So we've had a lot of questions about this. That does not mean that you can't change your agreement with your buyer. It does not mean that you can't amend your agreement. It does not mean that you can't have an addendum to your agreement. You can go back to the buyer and say, listen, I've worked for you for now 6 months. We've seen 100 different homes. I've come across a seller that's desperate to sell. They're going to pay me 2 times what my buyer agreement with you says I'm going to get paid. I think that I have the right to receive that. Please sign this addendum, and I'll go forward and we'll see this home, and we'll close, and it'll be a good transaction for both of us. That's all permitted. There must be a statement in the buyer agreement as well as in the seller agreement that broker fees and commissions are not set by law and are fully negotiable. We have a buyer agency agreement designated agency, a buyer agency agreement traditional in the RealComp form bank. As I said, our agreements comply with all of these requirements. As you can see down at the bottom of this form on page 18, slide 18, the parties understanding, knowledge, and agree that the foregoing agreement on compensation is objectively ascertainable and not open-ended. Why did I include this? I want, when the buyer signs this agreement, I want you to be able to say, if there's ever a dispute, my buyer signed this agreement. My buyer acknowledged that this compensation was objectively ascertainable and not open-ended. And below that, as you can see, it says Brokers shall not receive compensation for brokerage services from any source that exceeds the amount or rate agreed upon herein with the purchaser. Again, I want you to be able to say if there's ever a dispute, I did not receive more than what I told my buyer I was going to receive. There's a parenthetical there, unless this agreement is amended in writing by the parties. So you can amend the agreement. So changes to the MLS system and enhancements that we've had to make as a result of all of this. We've updated our forms, as I've said. We've got listing agreements that set forth the commissions. You can see this is a portion of our suggested ERTS seller agreement. Brokerage commissions are not set by law and are fully negotiable. And then we have a checklist of things that you can go through, percentage of the gross sales price, a specific dollar amount, variations on that. And we have an other category if there's some other form of compensation that you agree upon with your seller. We're continuing to monitor industry suggestions. As I said earlier, I've brought a lot of good questions to NAR. They've complimented me on some of the questions that I brought, which are really just questions that all of you have had, because they're actual questions that are going to exist with all of you on the ground and, selling and representing sellers and buyers. So they've been very good questions. Some of them were not fully thought through. The settlement agreement doesn't get into some of the details that all of us are concerned about, but the broad strokes are set forth here, and we have to try to work within them. So we've updated forms in Docs Plus. We've got a co-broker cooperation and compensation agreement. As I said, that's the agreement that we envision being one way in which two brokers can get together and decide on cooperation and compensation. And the seller, in the document that we prepared, the seller is required to initial each page. The seller is required to sign it at the end. Again, you can have a co-broker cooperation and compensation agreement with each different buyer. If you're a seller broker, you can have a different agreement with every buyer broker if you so choose. It can be different for each one. It can be different based on circumstances, based on difficulty, based on the house that happens to be for sale. And you could have them different ones based on all of the homes that you have in your portfolio of listings. So it doesn't have to be one set document. It can be variable. There's been some pushback on the length of it. Yes, it is a lengthy document, but it's designed to make clear both to you as seller brokers and to all of you as buyer brokers as to exactly what's happening. And it's designed to make sure that the seller understands what's happening so that there are no disputes. We have a limited service listing agreement. We have an exclusive right to sell or lease contract. We have an exclusive agency agreement. There's a purchaser agency agreement designated agency, a purchaser agency agreement traditional. There's an MLS only and entry only contract. There are more on the way. I'm doing my best to get documents out and into the form bank that you can all use. But again, feel free to use broker agreements, association agreements. Just please be sure that they comply with the highlights of the things that we're going through. And I will summarize at the end of this the 6 or 7 main areas that we need to all comply with. So one of the things, Karen's going to go through the details of how the MLS is going to look. Some of the fields are being changed, obviously, to implement all of this. There's been a lot of discussion over concessions, pre-sale concessions in particular. There was scuttlebutt and rumors going around that parties were going to use the pre-sale concession fields to sort of give a look at what their commission might be. They were going to do this inside the MLS. As you can imagine, as MLS counsel and as MLS advocates and MLS officers and directors, we were very concerned about this. In addition, other MLSs across the country were implementing pre-sale concession fields, and they were immediately chastised and subjected to a further review by the Department of Justice and by some consumer protection groups. The last thing I want for all of us, and by all of us, I mean all of you and the associations and RealComp, the last thing I want for all of us is for further Department of Justice scrutiny, further lawsuits, further upset to our day-to-day business. So in the interest of being conservative, we are not going to have beginning any pre-sale concession fields in the MLS. That does not mean, and this was done for a couple of reasons. It wasn't done just because we heard others weren't doing it. Nothing could be further from the truth. It was also done because we thought, how often will these pre-sale concession fields be used? How often is a seller going to immediately undercut its sale price by saying, well, I want to sell my house for $100,000, but I'll offer $10,000 in concessions. We thought that the likelihood of these fields being used was outweighed by the trouble that all of us could get into by having the pre-sale concession fields in the MLS. That does not mean that you can't offer concessions. That doesn't mean that in the purchase agreement that the buyer drafts that they can't ask for concessions. It doesn't mean that in the listing agreement that you have with the listing that you can't say concessions. There's some limitations on what we're going to allow because some of those documents are in the MLS, but it does not mean that concessions cannot be agreed upon as we go forward. So I think Karen's going to take over now and talk about some of the particulars of the MLS and some of the new fields that you're going to be seeing so that you all understand those. I will, after her presentation, finish up with some thoughts on the industry and a summary of where we are, and then we'll open up for questions and answers.
Thanks, Brian. One other thing I want to mention about forms, if you as brokers have your own forms that are available on Docs Plus right now, and you have not updated them to have these disclaimers and so forth that we've been talking about, or made the changes that we need in order for them to comply with the settlement, you will need to do that. You'll be getting some information from us asking that you do that. And if you don't have all of those forms updated by the 17th, which is the day the settlement actually takes effect, we will have to remove your forms. And we don't want to do that. So go in and pull them down, make the changes you need, send them back to us, and we'll get them uploaded for you on Docs Plus. There won't be a charge for that. So get that done as soon as you can, and you'll be able to use them moving forward. So we did not add the pre-sale concessions. We talked a lot about it to all of you and said they were coming. And then, as Brian said, the decision to which I think is a good decision, to not add those fields was made just last week. So, but we are adding some additional seller closing concession fields. Right now, you have access to, when you go in and mark a property sold from pending to sold, you're able to say, were there concessions? Yes. How much? And were they for this, or other? But we've expanded that. And the reason we're doing that is to provide additional information. Mainly the biggest request for this came from our appraiser customers that said we could use this information in appraising homes and making sure that the information is accurate and we have everything that we need. So these are the new fields you're going to see. The first you're going to see the disclaimer again, that in the concession field, you will not be able to make offers of broker compensation, disclose broker compensation, represent brokerage services are free. These are the same disclaimers you're going to see everywhere throughout the documents, throughout ad edit and on the listings themselves. So the first question is, were there seller closing concessions, yes or no? All of these fields are optional. You don't have to fill in anything, or you can fill in all of them if they apply. If the answer is yes, there were concessions, the next question is, how much concession was for closing costs, and you can fill that in. How much were for property improvement costs or new growth for driveway, you can fill that in. How much was for financing costs, and you'll be able to fill that in. And how much was for professional fees other than broker commissions, maybe attorney fees or consulting fees or something like that. You'd be able to fill that in. And then, of course, is the field for other. And other, again, has to be other than broker commissions. The next field is the total of those concessions. It will add that up for you. If you have figures in any of those boxes, it will add that total for you. If you choose to include just a total and not break it down according to these fields that you have here, you're able to do that. We're going to ask that you consider breaking it down because that's what we've been asked, but you don't have to. Again, none of these fields are mandatory. But if you fill in any of those amounts, it's going to add it for you, and there will be an amount in that total closing concessions amount.
Some of
The next field,
I'm sorry, Karen. Some of these fields were added to help appraisers. We had some input from appraisers that they wanted some breakouts of these fields, so we've added some of these fields in addition to.
The next field is the closing it's for comments. If you have any comments you want to make on these fields or these amounts. Now, what you're going to find is there are some blocking rules that will go in place. Same rules that you're going to have in place in remarks. So in the remarks and in this particular field, you will not be able to use phrases or words like buyer agent, dual, bonus. And that is done to make sure that none of the prohibited terms or information is included in the MLS. Up until this point, they were warnings, and it said, you know, you need to think about this before you put that information, and that's in remarks. But as of next Wednesday, all of these fields are going to be, they're going to block you from saving the listing. I believe on this particular field, it already does that. In remarks, that'll happen as of next Wednesday. So if you have any information, I don't know, Brian, if you touched on taking the commissions out of remarks, if there's any information in there.
I don't think I did. So
okay. So what we said you could do is, since the deadline was actually the 17th and we took away the commission fields, we said, yes, you can go ahead and put that information in remarks up until a certain point, and then we're going to have to ask you to take it out. You're going to get that communication delivered to you tomorrow that says, please, as of effective immediately, start going into your listings and removing that compensation information, commission information from any listing that you have. Because as of next Wednesday, you won't be able to add any more listings with that information, and we're going to go in and remove it from the listings you have. We don't want to mess with your remarks. We know how important those are to you. So if you know that you've added that in a couple of listings, please go in and make that change between now and Wednesday morning. Otherwise, we don't have a choice. We have to take it out because it's not allowed. And again, after that, just like with this, from that point on, you won't be able to add it. It won't let you. It won't allow you to save a new listing, and it won't allow you to save this change if that information is there. This is just the written version of what we saw. This is the status change form that you can print off, fill it out, have your seller sign it. This just explains exactly the same thing we saw on the screen on Add Edit, but this is just the written version of it. We wanted to give you some idea of what it would look like. This is what the listings will look like, and this is as of this week. So the top portion shows you in that pale yellow, this is what you used to see. Sub-agent commission, buyer agent commission, transaction coordinator commission, and compensation arrangements. Compensation arrangements included bonus, dual, variable, and excluded parties. That was what was in that particular field. It was one of the feature codes, the feature fields that you filled out, and it would then put that information in that field. Now what you're going to see, if you look down below, that compensation arrangements field has been renamed to listing exemptions, because that's the only thing that's left in that field that applies anymore. And a listing exemption is, let's say you have a seller who has a friend who's been looking at their home, or an acquaintance, and they say, I really want to buy your home. I'm just not sure yet. And they say to you, you can list my home, but if Joe buys it, I don't want to have to pay a commission. This is where you would put, and you agree to that. This is where you would say, yes, there are listing exemptions. There is an exempted party. And then down below, you'll see where the seller concessions will show. It'll say, yep, there's concessions. There's your text that you added. To the right of that, there's your closing costs, financing concessions, professional fee concessions other than broker commission, and so forth. And in this case, the user decided to simply put in the amount. They said $7,000. There were concessions. Again, we're asking you to consider filling in those fields because it will help many of our customers if you can do that. And of course, there's another disclaimer at the bottom. You'll see those everywhere.
So let me summarize, as I said, and give like a view of what might be transpiring going forward, and then we're to the Q&A portion of this. We're right on time. NAR and the big brokers argued very vociferously in the Sitzer and Morrill cases that this methodology of doing business, the fact that it was streamlined, actually made for a marketplace that created competition. It actually allowed buyers who might not otherwise be able to afford homes to buy homes. All of those arguments were made. Some very good arguments, many arguments that most all of us would agree with. That the system was working, that it was open and understandable, and that therefore it was an efficient market that led to better pricing. Unfortunately, those arguments did not carry the day, and this settlement agreement had to be entered into because, as you could ascertain from what I said at the beginning, $5.36 billion could not have been paid by anyone. It would have wiped out most of the industry, and that was just in Missouri. It would have been tenfold that in the Morrill case if there had been a loss there as well. So the settlement agreement had to be made. Really, there are seven things that you should focus on in making changes to the way that you practice real estate. And if you could keep these 7 things in mind, all of the other things can be set aside. No offers of compensation can be made on the MLS. We can't allow that. And we're going to do all of the things necessary that we need to do to prohibit that. You have to be sure that in your forms, whether they're real comp forms or association forms or broker forms, that you have in a conspicuous way set forth that commissions are not set by law and are fully negotiable. You cannot say that my services are free or there will be no charge, unless in fact there is absolutely no charge. If the seller broke, number 4, the buyer broker must have a written agreement with the buyer before showing the first home. This does not mean that you can't change that agreement going forward. It doesn't mean that you can't amend it, revise it, substitute it for a new agreement. But before you show your buyer the first home, you should have in place a buyer broker agreement. As I said, there are some exceptions. If someone is not really serious, you can go out and look with them on a Saturday or a Sunday or an evening. But if you have a client that is hiring you to find them a home, you have to have in place before you show them the first home a buyer broker agreement. Number 5, if the seller broker or seller is going to offer compensation to the buyer broker, the seller must understand this, it must agree to it in writing, and it must do so before any payment is made to the buyer broker. So you have to have in place some kind of an agreement that sets forth all of this. We provided one example in the real comp forms. In all agreements, both seller agreements and buyer agreements, commissions must be objectively ascertainable and not open-ended. So you have to be sure that the way that you describe your commission is it meets those standards. Again, it can be a sliding scale. It can have exceptions to it. It can say if this, then that, if this, then that. But it has to be objectively ascertainable and not open-ended. It can't say, I'll take whatever I can get, those kinds of things. And then last, the buyer broker cannot take more than what the buyer broker has disclosed to the buyer. Again, does not mean that you can't revise the document, that you can't change the deal. It's just so long as you get the buyer to agree to that, and the buyer does so in writing, you can take a different amount of fee than what you may have originally agreed to. One of the questions, I haven't seen the questions. There's a good number of questions, 17 or so, as I can see, that we'll get through. But a couple of the questions that I've faced in the past that I want to make clear is that these rules do not apply to leasing. So if you're showing a tenant potential places to lease, these rules do not apply. It doesn't mean that as a lawyer, I wouldn't suggest that you still have a good commission agreement in place. You want to get paid. You don't want any disagreements with your principal, the tenant. But if you're showing someone simply leasing properties, the settlement does not apply to simply leasing properties. It applies to the sellers and buyers of homes. Similarly, it doesn't apply in commercial transactions. If you are primarily a residential real estate agent, but you happen to have a client that wants to see commercial buildings, the same rules don't apply. Again, as an attorney, I would suggest that you have a good agreement in place, so there's no disputes, but the settlement agreement on its face does not cover leasing transactions, and it does not cover commercial transactions. So with that, I think we're ready. Oh, well, no, I've got one more what are we facing going forward? So we'll go to the next slide. As I said, this settlement covers plaintiffs who were the sellers of homes. There are similar lawsuits that have already been filed, that have been filed and have been out there for a year or more now, where the buyers of homes are suing in class action lawsuits, saying that they paid too much in buying homes because commissions were inflated, because sellers had to get more for their homes because they had to pay too large of commissions. There are those lawsuits that are out there. They have not been settled yet. Just a couple of days ago, there were reports that those lawsuits were on the verge of settlement. Hopefully they will be settled. Hopefully they won't result in large judgments against anyone. Hopefully they won't result in more rule changes, but there's the possibility that there will be further rule changes. As I also said earlier, the Department of Justice and the FTC continues to investigate and look at the real estate industry. What was basically found in the Sitzer case was that NAR, through its rules, which it implemented through the MLSs and which it required all the brokers to agree to, that those rules led to the coordination of competitors, which resulted in higher prices for everyone. The long and the short of it was that was the ruling. That was the finding. That was what the jury ruled, that NAR, through its rules, implemented through the MLSs, which the brokers and agents were required to adhere to get the capital R realtor by their name, was a means of coordinating competitors, and it resulted in increased prices, increased commissions. That's the long and the short of it. So NAR is looking, the DOJ is looking at other NAR rules to see if they're having a similar effect. And we don't know where that will lead. What's the future of NAR? As I said also at the beginning, the real estate industry is all of you are involved in a very important industry. It's one of the leading industries in the country. It's a leading economic indicator. Home sales up, home sales down. If you tune into CNBC in the morning, one of the first things you'll hear on the days that those things are reported is home sales were up, prices were up, interest rates were up, so on and so forth. It is a very important industry. NAR has been a an advocate for the industry. But whether or not it has done it in all of the right ways remains to be seen. What its future holds. NAR is one of the largest associations in the country as well. Besides the Teachers Association and a couple of others, all of you belonging to NAR has made it one of the largest and most powerful associations. So whether it has done all that it could to protect all of us, that's a discussion maybe for another day. What its future is remains to be seen. We at RealComp and all of your associations are looking very carefully at this, weighing alternatives, and we will keep you advised of those things as we go forward. One of the alternatives is whether there will be non-realtor participation in MLSs. Currently, that's prohibited by NAR rules, right? If there are non-realtors in the MLS, then you cannot have a capital R next to your MLS, et cetera. There are a few places where this is being challenged. There are MLSs in the country now where there are non-realtors that are members and owners, and it's maybe a trend for the future that we have to look at. Will there be other structures? All of you know of Zillow, of course. Zillow is a competitor of the MLSs. It's a competitor of the brokers, and it's a competitor of the associations. There may be new competitors on the horizon that will arise as a result of some of this upset in the industry. And of course, one of the things that's near and dear to everyone's heart is whether or not this will result in more professionals in the industry, less professionals in the industry. Are those professionals that represent only buyers at risk? I think that, again, this is my opinion only. I think that it might result in people that are doing it part-time or in a less than professional manner being weeded out because they don't understand the new rules. But for all of you out there that are professionals that do this full-time, that want to be the best professional that you can, that have a real buy-in in the industry, I think you'll all be in good shape, and we'll find ways to still to receive a fair commission and represent your clients in the best way that you know how. So that's sort of a look at what the future might bring. We're now at the Q&A portion of the town hall, so we'll be happy to answer questions for the next 45 minutes or so.
One thing I want to thank you, Brian. One thing I want to mention really quickly before we start answering questions. I don't know if this is one of the questions, but I want to make sure that I address it. We're asked a lot, can you put the commission information on showing time so that when somebody is scheduling an appointment on one of your listings and they're going to get a confirmation for that appointment, can it include the compensation information or an attachment that has that information? And the answer is no, you cannot. That's kind of like considered an arm of the MLS. We provide showing time for you. And showing time's owned by Zillow, which happens to be a brokerage, so they can't show that information either. Some people have already done that and they have it on the showing time screen and where you get that confirmation. They're working on removing that information. They've been talking to me about how they plan on doing that. So we'll make sure that you all know what you can expect there, but you cannot include the information there either. Okay, let's talk about questions. Are we able to take a referral fee from a listing agent if our buyer goes directly to the listing agent due to the fact that the buyer cannot pay a commission and if the seller is not paying a commission to the selling agent? Okay, we got to break that down now.
Wow.
I know, that's what I said. Can we take a referral fee from a listing agent? So, okay, if their buyer goes directly to the listing agent, due to the fact that so they're working with a buyer who can't pay a commission and that buyer goes directly to the listing agent to make an appointment or to make a deal for the property, can that first buyer agent get paid a referral fee from the listing agent? There's nothing that prohibits that.
No, there's nothing that prohibits that. Presumably your buyer, presumably the person who asked this question, presumably you will have an agreement with your buyer, right? That you're going to get paid some amount,
And
$1,000.
maybe, but it might say none because maybe the buyer knows they can't afford it.
Well, if it says none, then you're working for free, which is not recommended. But
No, they're planning on getting paid by the listing agent. And in this case, the listing agent's not, or the seller's not willing to pay it either. So they're just saying, can I have just a referral fee by sending my buyer directly to the listing agent?
yes, you can have a referral fee. Correct.
Okay. I'm not sure we're going to be able to answer this one, but we're going to go ahead. The onus of all of this mainly falls on the realtor. Real comp will still want their fees. Brokers will want their cut, and that leaves the realtor with having to charge the buyer for services, which most are not going to be willing to pay. What adjustments to fees from the association's real comp and brokers can we expect? I'll let Pat answer her part. We're not discussing any changes in our fee structure right now. Our fees are not changing as a result of this. I mean, our expenses are not changing as a result of this. What your brokers are looking at changing, I don't know. I can't respond to that. I don't know, Pat, if you want to respond to Pat, your dues are already so low. I don't know that you can make them any lower.
No, they're the lowest in the state, so we're gonna just continue with our $95 plus our small $15 assessment.
Okay. I mean, we track it very carefully, Mike. We pay very close attention to what we're spending, how we're spending it. We are absolutely aware of the fact that we have to be good stewards of your money. We know that. We know that, and we work really hard to accomplish that. So if at any point we can look at a change in the fees, then certainly we've done it in the past, and we would consider that again. If a buyer contract is signed and agreed to at 2% commission, and the buyer successfully purchases the home, the seller agreed to a 3%, what happens to the 1%? I know you can answer this one, Brian.
I can't answer this one. You should have in place an agreement between the seller broker and the buyer broker as to what happens to that amount. And if the seller broker is going to pay you 3% instead of the 2% that you agreed to with the buyer, you simply go back to the buyer and say, you know what, because you were such a good buyer and because we got this deal done, they're going to pay me 3% instead of 2%. Please sign this addendum to our agreement and we'll close on the transaction and we'll all be happy.
Where are the proceeds from the lawsuit going?
The proceeds from the lawsuit are going to the plaintiffs who are the plaintiffs that in the Sitzer and Morrill cases, and that really it covers all sellers of real estate in the United States between the years of October 2017 through the time that the settlement agreement was entered into in March of 2024. So you could do the calculation in your head probably. That's $417 million spread over millions of home sales. So the home sellers will probably get somewhere between $10 and $100 for this lawsuit. The people that make out in all of this, which I'm sure you probably all understand without me saying it, are the plaintiff's lawyers.
Yeah. Where can the buyer agency agreement, broker to broker agreement, as well as the new forms be found? Do they automatically update via RealComp? They are all on Docs Plus and RealComp's folder. If your question is, do they automatically update in your packages? If you have a package of forms that you use for your transactions, you'll need, we've sent out some information in the past that shows you how to go in and update your packages so that it uses the most up-to-date forms that are there. You'll get a little red flag in Docs Plus that says you need to update this form. If we've replaced one, it will show you that there's a new form for that. So if they do automatically update because we add them, and then if you have them in your packages, you'll need to update those packages to include the new one. And you'll see, like I said, that little red flag that will tell you how to do that. Do I have to have the buyer agency signed before I show a house? If the broker agreement on a commission amount, if the brokers agree on a commission amount, do I still need an agency agreement?
Yes. You need
Yes.
you need an agreement with your buyer before you show your buyer the first home.
Okay. Is it legal to include the subject and amount of commission in a purchase agreement?
Yes, it is.
We get that question a lot.
We do.
If someone sold a house in 2020 in the state of Illinois and moved to a different state, would he still be eligible for any compensation on the settlement?
Yes, they would. Now, of course, they're going to have to find that's part of what the plaintiff's lawyers are having to do. Plaintiff's lawyers are responsible for notifying all of the members of the class. So, and I've been on both sides of this myself in the past, in various ways. If you have to send out, you have to make every possible effort to get the notice to the class members. So if someone moved from Illinois to Missouri, the plaintiff's lawyers are responsible for trying to get notice to that party that they're able to opt into a class that they were a member of. So they would still be covered, but they would have to get notice.
If commissions are negotiable, do realtors have the right to refuse representation if their minimum sales commission is not agreed to? This is interesting. We just had that question today for the first time. In other words, can a realtor refuse to represent a buyer or seller that is unwilling to pay the realtor's set minimum commission?
Yes, you may. But again, and I answered it similarly this morning, the code of conduct, of course, has other rules and things that you're supposed to follow. So you got to be very careful. If you enter into a principal, and agents have a duty of loyalty, whether you're a lawyer or a real estate agent, you have a duty of loyalty to your principal, the party that's hired you. So that's why it's so important to have a written agreement that's understandable and that tries to cover all of the possible permutations that might occur. So if you sign an agreement that says, I will show you homes from September 1st to September 30th, and I will do that for $5,000, assuming that we close on a home, and then in the middle of September, you decide that you're, sick of working with this person, you have to go back and get an agreement, some kind of amendment that you're terminating the relationship. But in general, you can do that.
Just an opinion, but the two buyer agency documents developed do not indicate that the buyer agent can be paid by the seller side in the transaction. The verbiage makes it sound like only the buyer can pay the buyer agent. I feel something should be added to indicate seller payment to the buyer is allowed.
Well, I think that's a good question. Let me just tell you why we did the way we did with the RealComp forms. As I said, RealComp is the MLS. So our forms, and I struggled a lot with this. We struggled with this at RealComp. We struggled with this with the board. RealComp is the MLS, and RealComp agrees by way of the settlement agreement not to create, facilitate, or support any non-MLS mechanism for listing brokers to make offers of compensation to buyer brokers. By having that section in our forms, it could be used to accuse us of violating this section of the settlement agreement. I've included in our forms, the RealComp forms, an other section that would allow you to put into that a cooperating compensation agreement. But the RealComp forms have to be extra conservative. I'm sorry for that. I wish that it would be otherwise, but my number one job is to be sure that RealComp and the associations don't get involved in another lawsuit. That will only increase fees versus lower fees like you're asking. So we don't want to do that. So in the RealComp forms, there's an other section where you can fill this in, but we don't want to be participating as the MLS in a system of allowing cooperation and compensation of agreements. And by the way, there was a very interesting article that was just posted in Riz Media that talked about this very issue, where a major consumer protection agency said that that MLSs and other industry actors were trying to get around this rules trying to get around the settlement by doing X, Y, or Z. So I don't want to get into that hot box on behalf of RealComp.
Sounds like the co-broker agreement can be changed after showing the property if it's determined that the split should be different.
Correct. Yeah, absolutely.
Just that all parties have to agree and sign.
Absolutely.
Okay. Carmen, you were very good to put both your questions together. So is there an addendum to the exclusive right to sell for those signed prior to the new NAR requirements? And the answer is no. We did not make an addendum that would help, that you could add to your current agreement. We are recommending that you get a new agreement signed.
Right.
That covers these requirements. And especially if you have a pending sale you're waiting to close, we suggest that you get something in writing there as well. Because in the past, when it came to the closing and they said, what is the commission? You would look on the MLS and say, there it is right there. That's how much it is. And that's not there anymore. So if you don't have that in writing, it is highly recommended that you get that in writing. What happens? Oh, sorry. So with that said, if you have an agreement signed with your buyer for 3%, the seller's offering 2%, must we do an amendment to change this as well?
Yes, you should. This
is less than. This is less than.
So if you're anticipating that you'll get 2% from the seller and you're going to demand 1% from the buyer, you have an agreement where the buyer will pay you 3%. You can enforce your contract and say, look, I got 2% from the seller, and you have to pay me 1%. That's certainly an enforceable contract. If you choose to, work for something less because of the circumstances, then you can amend your agreement and reduce it. And again, I would, as an attorney, I would recommend that you be forthright and everybody be on the same page and you be clear. But you could enforce a contract that says you get 3%, despite the fact that the seller's only paying 2%. I'm sorry, Karen, but a good contract might say, I get 3% for recommending you. I will set off against the 3% that I'm going to collect from you anything that I can collect from the seller agent up to 3%. That would be a good contract.
What happens when the buyer doesn't pay the agreed amount? How will the broker get paid? Will NAR or broker legal teams represent lawsuits as part of their dues? No, I don't believe NAR is offering that service. No. If a home is listed at $500K and contains a plain 15K/15K in the remarks. Now, I'm going to assume that you're saying 15K to listing agent and 15K to the selling agent. That would get us in trouble, and that would get you in trouble if that's what that represents. And if it appears that that's what that represents, we would have to take that out because that shows the commission. I don't know if that's what you're saying, Mike. It's what it looks like to me. It's back in the old days when it used to have 50-50 or whatever it was. But if that's what that's representing, you would not be able to put that in remarks.
I think we said this, Karen, but we've had so many of these town halls. Sometimes I can't remember what we're saying from time to time. There's going to be limitations on what you can, there's going to be language and word limitations on what you can enter into remarks. So there will be some prohibitions on language. I'm sure people are very creative, so they'll come up with ways to foil us, but we are responsible for enforcing this. So we have to have limitations on the language and remarks.
So how do you handle dual agency transactions? That would be handled the same way you handle it today, would it not?
Yes, correct. The dual agency,
and that's
dual agencies are left to the brokers. We're not trying to substitute our knowledge or insight. We'll probably have a dual agency agreement at some point that we think that we believe complies with the settlement, but dual agencies are handled the same way.
Who is held responsible in making sure a buyer-broker written agreement is in place before a showing is scheduled? Does the buyer agent need to show the agreement to the listing broker?
Good question. We had this question. No, there's no requirement in the settlement agreement. Again, there's a myriad of ways you can look at how to implement this. I'm going by the strict language of the settlement agreement. The settlement agreement requires the 6 or 7 things that we talked about. Those are the things we're being sure that we adhere to. The settlement agreement does not require that the buyer broker show the buyer broker agreement to the selling broker. And the settlement agreement does not require that the seller broker show its agreement to the buyer broker. We think that in order to continue to meet the code of conduct and to continue to cooperate and compensate one another and to maintain an efficient marketplace, that you share the appropriate information at the appropriate time. One of the ways to do it is through this co-broker agreement, but you're not required. Now, I will say the caveat is this: if there is a dispute, if a seller broker comes and says to us that I paid the buyer broker 3% and they never had I learned later that they didn't have an agreement, or they had an agreement where they were only supposed to get 1%. So I overpaid because they're not supposed to get more than what they disclosed to their buyer. And there's a whole dispute. Then then the associations, Pat and her association and Real Comp, we're going to have some plans in place to negotiate, to mediate those disputes. And Real Comp will have fines. I'm sorry, Karen. Real Comp is going to be publishing a new set of fines that fine people that do not follow these rules.
What rules apply to light industrial? Is this considered commercial?
Yes, light industrial is commercial.
Okay, so that wouldn't be covered by this.
Would not be covered by the settlement.
Okay. Can we put in the Realtor comments only section a directive to a website that states what compensation is being offered?
Excellent question.
Yeah.
So again, because of the settlement and the settlement where the MLS Real Comp agrees not to create, facilitate, or support any non-MLS mechanism for listing brokers or sellers to make offers of compensation to buyer brokers or buyer representatives, we have determined that in the remarks section, we will allow a link to your web page. But it has to be to your main page. It has to be to the main page of your website. It cannot be to a compensation page. So we are going to allow a link that allows people to eventually get to what your compensation might be, but it's not going to be immediate and direct. I think that answers the question, right, Karen?
Yes.
I'm trying to remember these questions as you ask them.
If broker-to-broker compensation agreements lack conspicuous wording regarding commissions are negotiable, will they be removed from Real Comp docs available? So does the broker-to-broker document need to have those disclaimers too, Brian?
Yes.
They do.
Mm-hmm.
Okay, so the answer is yes. If they lack that, then it would be, then they would be removed.
Yep.
You have talked a lot about all of this legal info, but what you didn't mention is that the attorneys behind the lawsuit made upward of $300,000 to $400,000 in their pockets.
Oh, they made so just as a matter of interest, so you can take this for what it is. As a class action lawyer, you are entitled to get what the judge feels. And defendants argue, the defendant lawyers argue for one thing, the plaintiff's lawyers, you're entitled to get what is the reasonable, what the judge feels is a reasonable value of what you have delivered in connection with the lawsuit. So it's not an hourly rate. It's not a percent. Many of you who know plaintiffs lawyers know that they usually get somewhere between 25 and 33% of the recovery. It's neither of those things. The class action litigation rules say that you're entitled to a fair and reasonable amount determined by the value of what you've delivered. Of course, there are cases in the past and cases, all kinds of things by which people compare what they've delivered and what they argue as being the value. But there's no doubt that the plaintiff's lawyers will receive millions, if not tens of millions of dollars in connection with this. And the homeowners, some of whom are your clients, will receive, $10, $100, $500. So it's maybe inequitable. but that's the way the system works.
Good evening, Mr. Michael Young. With the final court approval due November 26th, do you think we could face more changes or new penalty provisions should there be widespread non-compliance over the next few months?
I do not believe that there will be any further changes between now and the end of the year and the time that this settlement is finalized. If the buyer cases settle and there are some rules that the buyer lawyers feel were unfair, or if the Department of Justice continues investigating other rules that NAR is perpetuating that they feel are anti-competitive, then there might be changes in the future, but I think those changes are out past the end of this year into next year if they occur.
We're being asked to identify the exact rule that applies to the conspicuous disclosure and negotiable requirements. I think the best thing to do, Shelley, would go for you to go to www.facts.realtor, and all of the disclosures. If you scroll down on that first page, you'll see all of the disclosures and disclaimers that NAR has put forth as part of the settlement. All of them will be identified there. Don't you think that's the best place to look for that, Brian?
I think it's a good place to look. Yeah.
Can our next presentation pair the ruling with the form content? I'm not sure I understand that. Russell, I'm sorry that you're unhappy with the answer. I don't know. I'm sorry, I don't remember which question was yours. If you want to repost your question, we'll address it again. But I don't know that I understand your question, Shelley, about the pair the ruling with the form content. So if you could explain that, maybe we'll come upon that as we scroll down to the other questions. How do we respond to our past sellers if they contact us directly asking about being compensated?
Right. That's a good question. I mean, most of you, I'm sure, represent people multiple times as they buy new homes, or the children of people that have bought a home from you, or the parents, vice versa. No, if they should receive, home sellers that fall within the class should receive notice of the class action settlement. Usually, you've probably seen these, you probably got them yourselves. The first thing is a card, usually a postcard that notifies you of the settlement. And it asks you then to either go to a website or some other vehicle for opting into the class, and you should follow the rules and the notices that allow you to opt into the class. As I said, unless you're a huge party with a lot of money that thinks that they can take on the industry, it's themselves, most sellers, I would say, should opt into this class and get, a portion of the settlement. It may be small, but if you want to receive something, that's the best way. And so you should tell your clientele the same.
Are we able to upload the broker compensation form to docs where the buyer agent can view it with the lead-based and seller disclosures? You may not include that there. To me, it cannot be a public document. You can add the broker compensation form to your packages that you have of forms within Docs Plus for your transactions, but you cannot say 123 Elm Street is offering this much compensation and upload it with the lead-based paint and seller disclosure forms. It cannot be there because that's in the MLS, and it would be a violation of the settlement.
Right.
So
unfortunately, we're not allowed. We can't.
No, I know it would make things easier, but no. Can a seller change the compensation agreement based on the offer amount? If they sign a listing agreement to give 2.5 to the listing agent and 2 to the buyer agent, but the offer is low, could they then change the buyer agent to a lower amount or remove it before accepting the offer?
Yes, they may do that. They have to notify their seller and be sure the seller understands that.
So all doable. You just have to, all parties have to sign saying that they understand and they have agreed.
Mm-hmm.
So it's all doable if everybody agrees. I saw on Facebook, this is pretty funny because I saw it too, Kimberly, picture of a keychain that shows commission rate on the property. Is that allowed? It was actually in a lockbox. The keychain was on a key that was in a lockbox. And when you opened the lockbox, it showed you the amount of the compensation.
Awesome. See, so much creativity. I love it. And if you post a picture like that in your in the pictures of your listing on RealComp, we might have to take that picture down.
But I mean, that's off the MLS.
Yeah, it's
so
off the
you could-
MLS, but if it's part of the list, if it's part of the pictures in the listing, then it's on
Oh,
MLS.
she was just saying that that's where she saw it. I don't think she was looking at posting it on the listing. I think
No,
she was saying, could that key be in the lockbox when somebody got to the home to show it? And they
sure,
opened the box and they saw that on there.
sure.
Okay, Russell, so the buyer can ask for the 1%. So your question was the difference between the 3% and the 2% and who gets the other 1%. So now your question is, can the buyer ask for that 1%? And again, that's between all parties to
Right.
determine where, if there's a difference in what's being offered and what was originally agreed to and what's being paid, it's up to all parties to decide where any additional funds would go or who would pay the additional funds that are being requested.
Right.
So
Remember,
everybody just has to agree to that.
right. Remember, as a buyer broker, you cannot get more than what you told the buyer you were going to take. But that doesn't mean you can't amend your agreement with the buyer to get more than what you initially said you would take. So if you said you were going to take 2%, but later on someone offers you 3%, all you have to do is go back to your buyer and say, because of the nature of this transaction, I am being offered 3% as opposed to the 2% that I agreed to with you that I would take. And so I want to amend my agreement with you to get the 3%. If the buyer pushes back and says, no, 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 I want that 1% applied to the sale price, so I'm paying less. I mean, then there's a dispute with you and your client, and you have to come to some settlement of that. But all you would be entitled to is the 2% unless you can get the buyer to agree to an amendment to the agreement to get 3%. I hope that helps. I'm trying to answer the question.
Let's assume someone shows a property to a client for the first time without an agreement, but the seller agrees to pay buyer agent compensation on the purchase agreement and we complete the closing. Okay, so the buyer agent and the buyer never have an agreement is the way I'm reading this. Maybe. Well, let me do it again. Someone shows a property to a client for the first time without an agreement. Okay, so there's no buyer agency agreement, but the seller agrees to pay the buyer agent compensation on the purchase agreement and we complete the closing. Does the buyer agent agreement have to be submitted with the closing package, and is it going to be audited? If I was going to give 2-word answers, I would say no and yes. It doesn't have to be submitted with the closing package, does it?
No.
But it will be audited. I don't, we haven't quite figured out how and how often, but we have to audit it. NAR is requiring us to do some kind of auditing. Obviously, we can't look at every one of them, but
we have we do have to have in place mechanisms to audit.
Yep, we do. Okay. Can we put a link in our website in the remarks where we're able to share commission? I think we answered this, that the link has to go from the listing to the broker website and from the broker website to the listing that you're requesting. You can't have a link in the remarks of a listing that goes directly to that listing on the broker site and shows the compensation. There has to be that in-between place where it goes to the broker homepage, and then from there they can search the listing.
That's correct.
Okay. Okay, thanks, Russell. I think New York scored though. I think they got a touchdown because you made me look.
Did I answer Russell? Do we answer Russell's question? Okay.
I think so. I haven't seen another part of it. So can we please be sent the list of 7 things that Brian stated is mandatory? Sharon, all of this information is on the YouTube channel. You'll be, all the slides and everything are there on the YouTube channel. And I think, Fran, are you not sending a link to the slides themselves? I'm not sure. I don't want to.
Yes, the link to the slides is in the video description.
Okay, so you'll have access to that as well, Sharon. Brokers have had discretion on the minimum commission they would allow a seller to pay. Is this now illegal and lays totally in the hands of the realtor? Brokers have had discretion on the minimum commission they would allow a seller to pay.
Well, I don't know that there's ever been a rule that has a minimum commission, but
Yeah.
but brokers brokers have discretion in whether or not, I mean, brokers have discretion and should make sure that the seller is fully informed of what commission, whether it's a minimum or a maximum, is going to be paid.
Yeah. Are listing agreements prior to August 17th required to be changed, or are they grandfathered? They are not grandfathered. It is advisable for you to change those to get a new updated listing agreement, even if it's before August 17th. There's no grandfathering any of these prior agreements. So you'll want to make sure everything is covered. Should we be still be sending the agency disclosure form showing how we represent the client? Yes, that hasn't changed. Whether you're an exclusive agent or a traditional agent, yeah, that has not changed.
All the same agency designations still apply.
Yep. The buyer says they do not want to look at homes that a seller does not want to pay a commission. How do we handle that in the buyer contract? Such a good question. Can we add a percent and then amend it to whatever the seller is paying and skip the homes that are not contributing? Great question.
That's a great question. And again, this was part of all of the defenses that the industry raised, that all of these problems are going to occur, that buyers are going to be less well represented, that buyers that are new buyers, first-time buyers, young buyers, disadvantaged buyers are going to be less represented, less able to buy homes. I think a lot of these are wonderful arguments that should have prevailed. But the long and the short of it is that you have to have an agreement with the buyer as to what you're going to be compensated. It can say, if you have to pay, it'll be $500. And if the seller is offering a commission, it'll be half of what the seller is offering as a commission. It can have variables like that, but it has to be in writing and it has to be understandable by the buyer. And if it changes, you have to get it amended, because you cannot take more than what you've told the buyer you're going to take.
And Brian, if you're working with a buyer who says, listen, I don't have any money to pay you, buyer agent, I don't have any money, then the buyer agent would have to be sure to show properties where the seller is offering compensation to that buyer agent.
Correct. The prohibitions would be, number one, you can't say my work is free. You can't say that.
Right.
We've talked about that. And we've talked about, I think you should make clear in your agreement that you're only going to show, you've got a duty to the principal as to what you're going to do. So you should make clear that, hey, if you cannot pay me anything, I'm only going to show you a limited number of homes where I am going to get what the seller is going to pay. But again, it has to be objectively ascertainable and not open-ended. So you have to have some certainty in there to satisfy that requirement. It's a tough situation. It's an excellent question.
It is. And it still has to show an amount. It still says, okay, I'll show you properties where I'm going to be paid X number of dollars or X percent. Right. It still has to be included. Yeah. Okay.
Or one way to do, or another way to do it. And again, there's a lot of ways, and the brokers are going to have to educate their agents on this, but you could say, I will get $500 from you. I will get $500 from you, buyer, $100 from you, $10 from you, buyer. And then I will get a portion of the commission that the seller broker is prepared to share, so that it has some variable to it, but yet there's a number in it so that it is, so that it is objectively ascertainable. So if you showed a home where you got nothing, you'd know you'd get at least $500 and you'd settle and you'd satisfy these requirements. Very difficult situation. I
It
understand.
is.
I've thought a lot about it, but it is something that we're going to have to work through.
I've had brokers tell me I cannot list a home for under a certain percentage unless it's for a family member or friend, and this was limited to once per year. That is true, strictly a broker policy. That has nothing to do with the MLS or NAR or any other rule. That would just be, that is simply the policy of that particular broker. So I don't know that we can address that. Thank you, Michael, for hanging with us. Brokers have had the discretion on the minimum commission that they would allow a seller to pay. I think we answered this. Is this now illegal and lays totally in the hands of the realtor? I mean, again, that's negotiated up front. You as the listing agent / broker negotiate with your seller on what they want to pay and how that commission is shared, if at all.
Right. And those are broker policies that have nothing to do with the MLS or the settlement.
Right. Thank you, Jamie. I'm going to read yours, Jamie. Thank you so much for all your support and for this update. I truly feel we pay for representation and support as realtors is top notch, and we should not be looking for discounts on memberships. You can always look for discounts, though. We have the best representation. Thank you for representing us and helping us to understand what's coming from the top. You know, here's the thing. Every day you're probably going to have another question. You have to know that it's okay to call and ask us. The only way you're going to find out is and you have to also know that we don't pretend to know the answer to everything. We don't know the answer to everything, but we'll do our best to get you an answer. Okay.
But I think we should say we also really, really care. Pat cares, Karen cares, the people at RealComp care. They're there at all times of day and night to try to answer the questions. I'm trying to lead everyone in the right direction. So we really care, and we're trying to solve these problems as they come up, and we'll continue to try to do that.
The seller doesn't need to see the agreement you have with the buyer, correct? So if the seller's offering more than the agreement you have with the buyer, seller need not know what you agreed with the buyer at all.
Correct.
You have to settle that between you as the buyer agent and the buyer to make sure that what you're accepting from the seller, it does not exceed what you've agreed to with your buyer, or you have to amend that agreement. That's the important part.
Correct.
I'm getting pushback from a realtor who doesn't want to sign your co-broker compensation form. They want me to sign theirs, but it lacks the conspicuous required language. I'd like to point him to the rule requirement. Okay, Shelley, let me see if I can find that for you.
Yep.
Let me see if I can find the rule, the exact rule. It'll take me a little bit of time to find that for you, but I'll see if I can find it. Yes, I saw that, Russell. It's disappointing. Lions 3, New York Giants 17. Just preseason though. Oops. I don't have a lot of time to waste, and I'm not working for free. So can I have my buyer sign an agreement that states they'll pay me 3% commission upon sale of home, and agree that they will allow their agent to only show them houses where the seller's offering to pay the 3% buyer agent commission? And if everybody agrees to it.
Right. Again, and this is a problem that was pointed out by the defendants. It's buyers are not being serviced as well because of these kinds of things. But yes, you can have an agreement like that.
So if the buyer and I agree to a flat fee that is less than 3% being offered, shall my buyer and I make sure that have the difference in writing to give to title company so buyer is credited? Okay, the buyer and I agree to a flat fee and it's less than the 3% being offered. Okay, so I think what you're saying is that the buyer would get the difference here. You're looking that the title company should be notified so that the buyer gets the difference. That's not necessarily the case unless everybody agrees to that. It may be that the seller keeps that extra money. Correct, Brian?
Correct.
So you have to have that all spelled out and agreed to prior to going to the closing. Where is that money going? Who gets it?
Yeah. Who's
And that has
who's it a credit to?
Yep. Can you add in the purchase agreement if buyer can't pay, if buyer agrees, understands, and purchaser agreement completed, that the seller will cover 2.5% in concessions to cover buyer commissions as a part of the total offer? Bingo. There it is. I think that's exactly the way that they're thinking it should be handled. That in the purchase agreement, if the buyer can't pay, that the seller is offering 2.5% in concessions that will cover the buyer commission as part of the offer. Correct?
Correct.
Yeah. So yes, Dave.
Correct. Yep.
Or
put it in, or put a variation on that is put that in. You're representing the buyer, right? You put that into your purchase agreement. We will buy the home for $100,000 plus a 2.5% commission to the buyer broker. Put that, and then have a buyer agreement. Have that in your purchase agreement, and then have your buyer agreement with your buyer say that I'm going to get a commission of 2.5%. All offers that I'm going to submit are going to have that condition in it.
At the buyer consultation, the buyer agrees to pay X%. They tell you they don't have any money to pay you and have to do it through the deal or co-broke. A home they want to see isn't offering buyer agency commission. If we don't show them the home, this is another really good question. Is it considered steering? And this goes to the crux of our side of the problem.
Mm-hmm.
Because you don't get to say you're working for free, but this is exactly what it's almost forcing you to do if they say, well, you have to show them the home or it's steering and you're not going to get paid. So if your agreement with them says you're not
in writing, exactly.
That's right.
In writing.
Right. If your agreement says that they don't have the money to pay you, and on this particular property, Daniel, it says they're saying that they're not offering buyer agency commission, then I wouldn't show them the home, first of all, because or go sit down and get everybody together and negotiate all over again. Go back to the listing agent and say, listen, we think we might be interested, but you got to meet us halfway or whatever the case may be, come up with some agreement. It's got to be in writing.
Right. It's not steering if you have in your buyer agreement that you have no money, you cannot pay me. I have to show you homes that are that have seller commissions off, that the seller is offering a commission to the buyer. I'm only going to show you homes where a seller commission is offered. And in those situations, I'm going to receive no less than 2%. Sign here. That's not steering. That's a contract. You have to make sure that the conditions are clear, but it's a contract.
Fran, go down to Sharon's question for me, please. Oh, wait. Where'd it go? I'm trying to get as many of these as I can that are kind of tied together.
I just clicked on answer live. Do you see it now?
Yes. How do we know which properties are offering a buyer commission? You got to pick up the phone, Sharon. You got to email. You're going to have to ask the question. And same with you, Angela. That's your question too. How will a buyer agent know what a listing agent's offering? You got to ask the question. Because that's goes again to the whole crux of this settlement is to make sure that everything is being negotiated and discussed. So you'll have to pick up the phone and call a listing agent or email them or whatever the case may be and make that inquiry.
See the plaintiffs in the cases were arguing the other side of this. They were saying, well, buyer brokers are going through the listings and are only showing clients homes where there's in the MLS an offer of compensation that's over 2%. They're not showing them the homes that are under 2%, and that's unfair. That is steering, and that's not allowed. So they argued the other side of it, which is the side that prevailed.
But if that's the agreement you have with your buyer, then everybody's
it's permitted.
Yep. I'm going to skip down to Deborah's question, Fran. If you're showing them only a certain number of homes because seller isn't paying and couldn't afford, couldn't we be challenged by the buyer as to fair housing since we're not showing all the homes with their criteria? Does the buyer agency agreement supersede this?
The buyer agency agreement, the contract with your client would supersede that.
Okay.
If it's clear and
Jamie says she loves you, Pat, and she appreciates you. And Kate says, well said. And what forms would need to be sent to Real Comp if audited? I guess it depends on which ones we ask for. Currently, we might ask for exclusive right to sell. We might ask for the buyer agency agreement. It depends. It could be any of those. I think we said any of the exclusive right to sell, any of the buyer agency agreements are listed on our list of possible ones. Just going to answer a couple more quick ones, and then we're going to let everybody go to bed. You're welcome. You're welcome, Jamie, and you're welcome, Veronica. We appreciate all of you too. Are the lending companies on board with the change? I don't know. I honestly, we didn't get to that part yet. You know, we talked about reaching out to them so that we can talk to them about these changes. Thank you for bringing that up, Russell, because we were asked about that, and we probably need to reach out to some of these top lenders and just talk to them about these changes to make sure they are prepared and they are aware.
It's a great question, Russell.
It is.
The settlement agreement does not require that the lenders be on board with this. So the settlement agreement, which is the number one concern of ours, all of ours, the lenders have no input into it. There are discussions amongst the appraisal industry, NAR, and lenders as to how to handle all of these things. But those discussions are ongoing. There's no clarity yet.
Nicole, you're saying that last week a listing agent refused your showing request until you would email them a copy of the buyer agency agreement. Absolutely not. The buyer agency agreement is between you and your buyer. It is not between you and your buyer and the listing agent. In that case, if that happens, I would assume you would probably call us or email us, and we would reach out to the listing agent to make sure that they understood that, because that is not required. So if we find out verbally, the listing agent, what the commission is, but you don't put it in, when does it get put in writing? Kate, I would say immediately. If they say it's whatever it is, have them text you, have them email you, have them fax you, if anybody even still has a fax machine. I would get it in writing immediately. Okay, I'll have to come back to your last question, Mike. Thank you, Russell. And you're welcome, Nicole. We're glad that so many of you hung out with us so late. And okay, thanks, Deborah, for letting us know the lenders are trying to accommodate. Again, there's going to be more questions, so absolutely if you need to reach out to us and ask those questions, please do not hesitate. You know where to find me, you know where to find Pat. If there's questions that I can't answer that need Brian's input, I will reach out to him. He knows that, and we'll get to the answers that you need. We truly appreciate all of you learning about this as we'll have to wait and see how some of this shakes out, and we might need to make more changes, but thank you. This year Real Comp celebrates our 30th year in business, and we wouldn't be in business without all of you. So thank you, and have a good night. We'll let you all go to bed.
Thank you, everyone. Thank you, Pat.
Thanks, Pat.
Thank you, Karen.
Yep. Bye, everyone.